Hey folks, Dale Davidson here, Davidson Law Offices. Certainly glad you're here today. Hey, got a treat for you today. We're going to be talking about estate planning. Woo-woo! Let me start off with a kind of a quote. Everybody knows this Susie Orman. She's a big financial guru out there. Well, this is her quote. Estate planning is an important and everlasting gift that you can give to your family. Setting up a smooth inheritance isn't as hard as you might think. And again, that's from Susie Orman. Here's another one from a Napoleon Hill. It says, hey, don't wait. The time will never be just right to do your planning. So, question for everybody. Have you ever seen an armored vehicle following a hearse? Realize that you just can't take your stuff with you. You can't take your money with you. You can't take your real estate with you. You can't take your property with you. So here's a little joke here that I heard the other day. The guy was on his deathbed and he told his wife, he said, look, I want you to take all my money and put it up in the attic so when I go to heaven, I can take it with me. So shortly after he died, the wife told the son to, hey, go up in the attic and see if all that money's gone. Went up there in the attic and says, Mom, money's still there. He says, you know what, I told that guy to go ahead and put it in the basement. So anyway, my joke for the day. Not a very good one, but that's all I got for today. So we accumulate stuff during our lifetime, right? So what are you going to do with all your stuff? And I'm calling stuff your bank accounts, cars, trucks, boats, guns, fishing rods, whatever you got stuff, okay? Maybe it's solely in your name or in the name with someone else. Maybe you own a house with you and your spouse, okay? And so maybe it's in joint names. So there's basically three ways to hold property in joint names, okay? Joint with rights of survivorship means when I die, my spouse gets my house or whatever asset I have, joint with rights of survivorship. Number two, tenants in common. I die, I still keep my tenants in common property goes through my estate. It doesn't automatically go to that joint tenant or the one I have in common. Maybe I have a piece of real estate between me and my brother-in-law. Well, it's tenants in common because if I die, I don't want him to get the whole property. I want my wife or my spouse to get that property, so it's tenants in common. And then a special one that is called tenancy by the entireties. This is basically for Florida property, a husband and a wife, okay? So depending upon how things are titled, you may or may not have to probate. And we're going to talk a little bit about probate. So again, title to everything you own really matters. Okay, get that from this video. Title matters. Okay, so during your lifetime, how you hold title is important because if you own it solely, you control it, right? And you can do whatever you want to. But if you own it joint with somebody else, some of your control is diminished. You own it jointly with your spouse, you can't sell that property without your spouse's consent. Okay, you own it tenants in common. I can't sell that property unless I get my brother-in-law's consent. Okay, so during my lifetime, title matters on how much control you actually have. So what happens when you pass away and you have assets in your sole name? Well, you got to probate, right? But regardless of whether it's in your sole name or tenants by the entirety or joint with right of survivorship or tenants in common, your heirs are going to have to do something with respect to your stuff. Now, that may be as simple as filing a small estate affidavit, depending on your state law. It may be as simple as filing an affidavit of title facts showing, hey, Dale's deceased now and this property goes directly to me, or filing a death certificate, same way, okay? There's going to have to be some action on your heirs to do something with your stuff. The question is, are you going to have to probate, okay? Now, again, probate depends upon how things are titled Are they titled in your sole name or jointly with somebody or tenants in common? Okay? So, you either are going to plan for what happens to your stuff when you pass away or you don't. Either you plan or you don't. Those are your two choices. There's no in between here, okay? So, if you don't plan, meaning you don't have a will, okay, then you're going to pass and your assets will be passed in accordance with what we refer to as the intestacy laws. That means the government is going to tell you who's going to get your property, how they're going to get your property, and when they're going to get your property. So under the intestacy laws, you did absolutely nothing. You didn't plan a thing, okay? You don't have a will. You didn't title your assets jointly with anybody, So now with an intestacy, you're gonna have to go into some kind of court proceeding. Now, we call those an administration here in Georgia. Your state may call it something different, okay? But since you passed intestate, and since you don't have a plan, the government has a plan for you. Now, the disposition of your assets depends upon the state plan, not your plan. So, question. If you die intestate, do you think your spouse is going to get all of your stuff? Now, qualifier, you have children. Well, the answer to that question is absolutely no. If you think everything is going to your spouse on your death and you don't have a will, well, I guess it depends on your title to those assets. But if you've got something in your sole name, guess what? It's not going all to your spouse. Hey, if you got adult children from a previous marriage and your spouse survives you, do you think your new spouse is going to get everything? No, not at all. The general rule is that your new spouse would get a child's share, but not less than a third. So let's have an example here that you've got two children and a wife or a husband, whoever it may be, okay? So your spouse would get 1/3 and your children would get 2/3. So your children now own your house 2/3 and your spouse owns 1/3. So your children now own property with not their mother or father, but with their step parent, okay? I smell trouble in those situations, okay? So if you pass and you have an estranged child, he or she is going to receive a share of your estate whether you want them or not. Why? Because you didn't plan. You didn't do anything. You died intestate. If you have a child who has special needs, who's disabled, okay, and they're receiving government benefits, what you have done is you now have disqualified them from receiving those benefits until their inheritance from you is spent down. Then they have to go back and reapply. So you can see there's a lot of different problems with dying intestate. There's a lot of problems dying without a plan, okay? Intestacy takes longer and it's much more expensive. It's much more involved than a probate. But again, you don't always have to probate, and we're going to talk a little bit about that in just a few minutes. So, the flip side of intestacy or administration, we call that probate. Congratulations, you planned here and you had enough forethought. You took Susie Orman's advice and said, look, I'm going to get a will. So you've got a will and now you've got a plan, okay? Everybody should have a will. If you're over the age of 18, you should have a will. You may not have a whole lot, but you may have a car, bank account, things of that nature. But you should have a will. Now, a will does not guarantee that you have to probate, okay? It doesn't guarantee that you have to probate. What guarantees that you have to probate is how assets are titled. Again, if they're in your sole name, guess what? You're going to have to probate. If they're in joint names, joint with rights of survivorship, don't have to probate. Tenancy by the entireties, you don't have to probate. Tenants in common, that's a joint name, but guess what? You have to probate. All right? So title means everything in this instance, okay? So what is a will? What does a will do? So a will is where you name somebody, whether they be called the executor or the personal representative, fiduciary, whatever. So they go to after you pass away, they go to the probate court and say, look, this guy's passed away. Here's the will. Here's a petition. Appoint me as the executor or the personal representative. I'm going to gather up all the assets, and then what I'm going to do is pay all the bills, and then once all that's done, I'm going to distribute the assets in accordance with what the will says. Okay, that is the probate process in a nutshell. So as a general rule, probates are quicker, okay, than an administration, because in an administration we have to file notice, we've got to get all the heirs to consent and all of that kind of stuff. Well, a probate, as long as all the heirs have consented, then usually you don't have a notice that you have to run in the newspaper to notify people of the administration. You just get all the heirs to consent. So as a general rule, it's quicker and of course less expensive, because a probate takes anywhere from 6 to 9 months and sometimes even more. Fun fact, I've got a probate that's been open since 1977. Crazy. We're going to get that closed up here real soon though. So, but in a probate, just like in an administration, you've got to wait for creditor's period to run before dispersing any assets. And if a creditor makes a claim, you got to make sure that that claim is satisfied, or you have enough assets to satisfy that claim. So, administration, intestacy, probate, you've made a plan and you have a will. So, now that we kind of educated you on the importance of planning, and planning is very, very important, okay? Let's go one more step, because you could benefit from, everybody can benefit from knowing this, okay? You do not probate assets if they are joint, like tenancy by the entireties, or joint with rights of survivorship, okay? But have you ever heard of like a living trust or I like to call them revocable trust? You don't have to probate assets in a living trust, okay? You do probate assets in your sole name. You do probate assets that are in name, tenants in common with somebody else, okay? So what if everything's titled in the trust name? There's no probate at all. Doesn't matter if it's tenants in common or not. Of course, when you transfer things into the trust, we sever those because the terms of the trust control. So all your real estate, your brokerage accounts, your checking accounts, savings accounts, stocks, bonds, tangible personal property, they're all in the trust, and so they're not subject to probate, okay? Do not, and I'm going to repeat this, do not under any circumstances try and transfer any kind of IRA, 401k, annuity, or any other type of qualified plan into your revocable trust. That is a huge no-no unless you really want to pay a bunch of taxes, which I don't know of anybody who likes paying taxes. So, but let me kind of explain to you what a living trust is. Now, I did a video a couple of months ago, maybe a long time ago, and I talked about wills and trusts like this, and I had given you an example of my trust bucket. So let me show you what that is. So, simply put, this is a trust. I know it's a trust because it says trust, okay? All right, it says trust here. So, a living trust is just think of it as a bucket. You can have your money in here. You can have your land in here. You can have your house in here. You can have your stocks and bonds. You can have all kinds of assets in your living trust, okay? And what's great about these things is that you control 100% of what goes in and out during your lifetime, and so long as you're able to. So you can take money out, spend it. You can deposit money, okay? You can buy stocks, buy and sell stocks, land, whatever you want, and it goes into this trust. And see, that trust is controlled by you during your lifetime, okay? So you can take it out and spend it or save it, do whatever you want to do. And what happens upon either your disability or your death is, see, we put a cap on it. And now it becomes irrevocable, meaning you can't, nobody can change it. This is for you and for you alone. Now, let's pretend that you're disabled. Now, so you're disabled, so the trust, whoever you've named as your successor trustee steps into your shoes and they start administering the trust for your benefit. They pay you money. They pay your bills, whatever it may be. You have some language in here. Maybe you say, I don't want to go to a nursing home. My intent is to stay at home, and I want this trust to pay for everything, even if I exhaust all my assets. So your trustee pays for home care, caregivers to come in, whatever it may be for your sole benefit. You're still alive, so this trust is still for your sole benefit. The trustee can't go and pay his or her own bills. Got to pay your bills, okay? Got to use the money for you. Now, upon your passing, again, the trust becomes irrevocable. What happens? Well, you designed the trust. You said, okay, I've got 5 kids. One of them is a special needs child, so I need to have a supplemental needs trust within this trust. Well, we can do that. This is a blank canvas. We can paint whatever picture you need. Okay, so we've got a supplemental needs child. The other 4 children would get their whatever they're going to get in trust for their lifetimes, or we could do a generation skipping. We can do any kind of things you want, or give it to them outright. It doesn't really matter. This is what you want to do with your assets. So we're not dependent upon the government to tell us what to do or tell you what to do. This is your plan, because you had the foresight and the knowledge to say, look, I don't want to probate. I don't want to delay getting benefits to my kids, or to my spouse for that matter. It could be your spouse or anybody else. So you have this trust because there's no downtime. We don't have a creditor's period necessarily in these revocable trusts because we don't have to probate. Okay? I'm not saying that the creditors can't get to assets if you've got creditors out there. This is not a creditor protection vehicle. But we don't have to file the notice to creditors a lot of times. But it depends on your state law. So that's a trust kind of in a nutshell. So let me kind of recap the trust, because people think it's kind of complicated, but it's not. Think of the trust as the bucket, okay? I just had the bucket up here. During your lifetime, you control 100% of what comes in and out of that trust. Nobody can tell you what to do with your assets. Those are your assets, not somebody else's. Now, you've named somebody as your successor trustee in the event that you become disabled. If you become disabled, that trust becomes irrevocable, means nobody can change it, and the trust pays your bills still. You're still the sole beneficiary of that trust during your lifetime. Again, not supposed to be paying somebody else's bills. They're paying your bills, nobody else's, okay? So when you pass away, then we look to the terms of the trust and say, okay, what happens here? Where do my assets go? my example, I had 5 kids. One of them had supplemental needs. So we had a trust within a trust. You can have trust within trust within trust if you want to. That preserves and protects my disabled child's benefits. For instance, maybe he's receiving some kind of SSDI or something like that. You can't have assets in your name. You can't have too much income. But there are things that he may need or require that the government benefits aren't paying for, so this trust can pay for those. Okay, so revocable trust, living trust. Now, what the pros here are that we don't have to probate. If you become disabled, your successor trustee just steps right into your shoes. On your death, your successor trustee steps into your shoes and operates the trust, okay, and distributes the property out well within, well before the 6 to 9 months, generally for a probate or administration. Now, they do have some cons. They're a little bit complicated, but that's what we're here to do, is to help educate you on how to operate these. We'll show you how to transfer your checking accounts and savings accounts, your real estate. All of those things will be transferred in there, because guess what? Those trusts don't work to avoid probate. They don't work if you don't pre-fund them. You got to put your assets in there during your lifetime. Now, they're a little bit expensive on the front end, but if you compare the expense on the front end of a trust versus the expense of a probate on the back end or an administration, and waiting 6 to 9 months, that the front end expense is pales in comparison. So, hey, thank you for watching. I hope you got some really good information from this video. Got another video right here that I did a while ago on trust. I got my trust bucket out there for you. Got some good information. Go check that one out. And until next time, be blessed.